Every day brings a fresh round of attacks and counterattacks over the collegium system, where the government and the judiciary are pitted against each other. If you watch this show, you know exactly what has been going on in the last 3 months. Today, however, Law Minister Kiren Rijiju struck a conciliatory note. He said there are differences between the judiciary and the government on many issues, but there is no Mahabharat underway. Now, interestingly, yesterday, Mr. Rijiju had publicly backed a retired High Court judge who had said that the Supreme Court has hijacked the Constitution. Listen in to what Mr. Rijiju is saying today.
सुप्रीम कोर्ट के कुछ व्यूज होते हैं, सरकार के कुछ व्यूज होते हैं. अगर उस व्यूज में कुछ डिफरेंसेस होता है तो कुछ लोग उसको ऐसा पेश करता है कि यहाँ तो महाभारत हो गई है सरकार और जुडिशरी के बीच में. बिल्कुल ऐसा नहीं है. हम हर शाम हर सुबह किसी न किसी रूप में लगातार मिलते रहते हैं.
वो महाभारत thinks that the judiciary and the government are at loggerheads is the basic structure of our constitution. In a landmark judgment in 1973, the Supreme Court had ruled that while the government can amend the constitution, it cannot touch the basic structure or our foundational principles. Now, Vice President Dhankar has attacked that judgment, saying that Parliament's sovereignty cannot be compromised by the judiciary. But yesterday, the Chief Justice of India responded to that attack. He said, and I quote, "The basic structure of our constitution, like the North Star, guides us when the path ahead is convoluted." So there are interesting statements that have come in the last 24 hours. Gopal Shankaran is a senior advocate. He is joining us on the broadcast. Thank you very much for your time here, Gopal. Can I ask you, is this Mr. Rijiju offering the peace pipe to the judiciary, as it were, saying that there is no Mahabharat underway? I mean, of course, there are differences between the judiciary and the government, but the press hypes it up to be some big war, which it is not.
No, thank you for having me on the show. I think it may have been a little bit of pressure coming on Mr. Rijiju to try and tone down the tenor of what he's been saying. In fact, what he said yesterday seemed to be more objectionable than what he has said in the past, because he said no sane person would agree with this position. He's suggesting, therefore, that most of those who believe in constitutional governance, including, I'm sure, the judges of the Supreme Court and the High Court, people like me and you, and I'm sure many others, are people who lack the sanity. I think that may have come across as a little too strong, and he must have been told to tone that down. There's no question really of a Mahabharat or any kind of battle. I think many people have said in the past, and I think it's a good thing, that there is always a little bit of discomfort between the executive and the judiciary, which is as it should be. There should be checks and balances in place. But I want to respond, I think, to that one point you touched upon about the chairperson of the Rajya Sabha taking objection to the basic structure doctrine. I just want to give you a little bit of a backdrop. The Keshavananda Bharati judgment, which laid down that basic structure doctrine, was a 13-judge bench, which overruled a previous 11-judge decision of Golaknath in 1967, which said that the fundamental rights of the Constitution cannot be amended. Now, to undo that, there were some amendments that came in, particularly with reference to and arising out of property rights in the Constitution. Now, if Keshavananda Bharati is wrong, you go back to what existed before that, which is the 11-judge decision, which said that fundamental rights cannot be touched. I'm fine with that. That's even better than what we have with Keshavananda Bharati. The only thing that Keshavananda Bharati does is that it goes a little beyond just individual rights, which is protected. And it says independence of the judiciary, exclusion of judicial review, being bad, free and fair elections. All those things are the fundamentals of the basic structure. Please note that when Indira Gandhi was at her power, she tried to bring in an amendment which said that nothing she does could be questioned in a court of law. Her elections could never be questioned in a court of law. And the court struck that down on the basis of the basic structure. The fact that courts could not go into defection questions was struck down again on the fact that one part of it was dealing with the basic structure. So constantly you have basic structure being used as a check. If we did not have the basic structure, we could have a powerful amendment coming in, which said that, for example, certain religions or certain castes would not have the right to vote. You could bring in a constitutional amendment saying that they don't have a right to education, right? And that's not the kind of country we want, and that's not the country that was planned for us either.
But Gopal, fact is that, the argument that comes in from the government very often is that the will of the people is supreme. And the parliament represents the will of the people. So if we want a say, in appointment of judges, what is wrong? Why do you see a conspiracy around that? I want to ask you, you're telling me that, there is some sort of pressure on Mr. Rijiju, which is why this peace pipe was offered today. We don't know, how long this will last, because all you know, tomorrow you could see another statement coming in either from Mr. Rijiju or Mr. Dhankar, because, these daily missiles have been coming our way for the last 2 or 3 months. But when the government does argue that the collegium system is opaque, there are problems with the collegium system, what's the problem if the government has a say in appointing judges? We are not saying we are the 100, we have 100% say, but at least give us 40, 50%. What's the harm in that?
No, I don't think there is a particular harm in the executing having a say. At the moment, they do have a say. Every single IB report, which for many, many years, they have been relying on to try and stymie the names that are proposed by the collegium. Thankfully, last week, the collegium has finally made it transparent, and we can see the kind of absolutely rubbish reasons that the IB proffers to try and block appointments. Right? We've fortunately, for the first time, it's come out in the public thanks to the collegium uploading it on their website. So we know the kind of stories. So I think it's not that the executive doesn't have a say. Right now, what they've been doing, and they've been doing this for the last 7-8 years, is that when a proposal comes to them that they're not happy with, they don't send it back, because if it's sent back to them a second time, it's binding on them, right? So they just sit on it. They do nothing. They just sit on it for months on end, and excellent candidates who should have become judges actually withdraw. My dear friend Aditya Sodhi, who's an outstanding candidate with a great practice, a senior advocate from Karnataka, at a very young age was offered, and he had said he would like to, and then he withdrew it on 365 days, it being sat upon by the executive. So that's a problem. I'm seeing that people look at it as if the executive doesn't have a say. They have a say, and they're using it in a very, very strong fashion to block names that they're not happy with. But over time, I think they've also realized that they can't do much more. And that's what Rijiju said last week, that we should have a say at the front end. We should have a say in the names that get proposed, that they don't have right now. Maybe informally they could suggest a few names, but it's not a formal process. I think we should, if at all we're moving towards other systems, we should move towards something that is much more broad-based than just the politicians who are sitting in parliament and through the executive suggesting names. I think there should be members of the public involved, and maybe we could nominate people, because right now we have reached a stage when more than 42% of our members of parliament and our MLAs are those who have very serious criminal charges against them. Are those the kind of people that we're going to trust with recommending judges? Or is it fine that we go with the collegium at the moment?
Okay, Gopal Shankar Narayan, we leave it there for the moment. Thank you very much for joining us in this very interesting development that came to us barely 40-45 minutes ago. Thank you very much. Good to have you on the show.